First, we will be finishing the codes. So comparative study is really very important. I'm not going to explain each and every section or read each and every line. I will go and concentrate on only those matters or only those provisions which are newly added or which is cooking. Okay. So Industrial Relation Code of 2020. What is the background of this codes? Why these codes came into the existence? The first and foremost thing about this all four codes is, like, Second National Commission on Labor, when it submitted its report in 2002, the purpose or the objective, or you can say the basic recommendation which this Second National Commission on Labor recommended, that there should be an umbrella of the legislation under which different legislation have to be covered. Why umbrella? So umbrella reason, it would be applicable uniformly. Now every law, every legislation requires to check an applicability or eligibility in single individually, but when umbrella legislation would be there, in together a complete code would be applicable. So there one recommendation that was that umbrella legislation should be covered, or umbrella legislation should be created. Another important thing was that Second National Commission specifically concentrated or specifically have stressed on covering unorganized sector. As Indian industries are growing, as we are developing, technology is growing, the number of unorganized sector anyways was always higher side in India. But over the period of the time, the activity into this unorganized sector have been increased. So there has been or you can say there has been new businesses which have added to this unorganized sector, like your online shopping, then your services, like that forms the part of the quaternary market. Okay, the online services, which is an extension of tertiary market, a quaternary market. So in order to bring the unorganized sector under the preview of this legislation, for that purpose also the code was formulated. Another thing, it was to amalgamate the differently separated legislation into the codes for better reach, for better applicability. One of them code is Industrial Relation Code 2020, based on your regulative principle. What do you mean by regulative principle? The purpose of this code is to build good relationship between employee and employer, and to provide settlement machineries for the dispute. This code, prepared by amalgamating, simplifying and repealing 3 labor acts: Trade Union Act of 1926, Industrial Employment Standing Order Act of 1946, and Industrial Dispute Act of 1947. So this all 3 regulative are being amalgamated together, simplified together to form the code. Now, in this particular law or code, basically code, there are 13 chapters and 3 schedule. How many chapters? 13 chapters and 3 schedule. Chapter 1 talks about short title, extent and commencement, applies to whole India. It will come into the force whenever the central government, by the notice in the official gazette, describes or gives the date. This date can be different for different provision, different chapter. Means trade union can, the chapter number trade provisions for the trade union chapter can be different. The date for the Industrial Employment Standing Order can be different. It depends upon the central government how it is defining the dates. Appellant authority. See, this is already being explained you into the earlier laws, so not going into the detail. Okay. The first definition given here is appellant authority. Appellant authority means authority which is appointed by the appropriate government to exercise all the functions which is being given to it by the government. The appeal, the term from appeal, the appellant authority has come. The purpose of basically the appellant authority is to listen to the claims and the appeals. Now, appropriate government definition is important because here the new things has been added. As I was saying that it wanted to increase the scope of the industries, larger industries or larger area should come into the scope of this code. There has been new things which has been added. What are they? The first is central government would be the appropriate government, where The undertaking is carried out by the authority is under central government. Establishment, railway, mines, oil field, major port, air transport service, telecommunication, banking and insurance, company or corporation or authority established by the central law. So what things are added? Telecommunication, banking and insurance, and company or corporation formed by the act, or a central public sector undertaking. When we studied Industrial Dispute Act's definition, their central government and state government definition, here mines, oil fields, major ports, air transport was there, and here public sector undertaking. Here state public sector undertakings were there. Here now they have added or central public undertaking. Subsidiaries are also now covered. Subsidiaries, companies set up by the principal undertaking or autonomous bodies owned or controlled by central government. This is new added, subsidiary, autonomous body, including the establishments of contractor for the purpose of such establishment, corporation, authority, public sector undertaking, or a company not less than 51% or paid up share held by the central government. So all those corporation, all those establishment of contractor, all those public sector undertaking whose 51% paid up share capital is held by the central government, for all of them central government would be the appropriate government. What all things added? Telecommunication, banking and insurance, subsidiaries, autonomous bodies, contractor establishment holding the 51% of share capital, state government. Any of the industrial establishment, including the state public sector, subsidiary, companies set up by principal undertaking, autonomous body owned by the state government. For all of them, state government would be the appropriate government. So what is the appropriate government? Section 2B defines the further case that who would be the appropriate government if there is a dispute between the contractor and the contract labor employed in any industrial establishment. So if there is a contractor and contract labor, there is a dispute. So when it comes to the dispute, who would be the appropriate government to check or refer those matter to the tribunals or to the higher court? So in case if the contractor and the contract labor are the part of the industrial establishment which is under the central government control, then central government would be the appropriate government. If it is the industry which is under the control of state government, then state government would be the appropriate government. Arbitrator is the new term which is being implied you can say defined properly in the section 2C, which includes umpire. So this is something which is being added. We know cricket mein umpire, so the term is taken there. Umpire is the person who gives the final decision, so it will include the umpire. Another important, this was in Industrial Dispute Act as well, here also. What is section 2D defines average pay, means the average wages payable to a worker. If a person is monthly paid, 3 months calendar will be taken as average. When we calculate the compensation, we usually say average pay. So what does this average pay means for a monthly period, monthly person? So if you have to calculate an average pay or for the person who is monthly employed, you have to calculate his 3 complete months. Then in case of weekly, 4 complete weeks. In case of daily, 12 full day working. Added in section, defined in section 2D. Award, same thing. Here, the only thing is labor court is not there. Any interim which is being given by industrial tribunals, national tribunals. Okay, that is your award. Banking company, since now banking company are also included, as defined under Banking Regulation Act of 1949, include Export Import Bank of India, Industrial Reconstruction Bank of India. So what is included in the banking company's definition can be asked. Export Import Bank of India, Industrial Reconstruction Bank of India, Small Industries Development Bank of India, established under the Small Industries Development Bank of India Act 1989, Reserve Bank of India, State Bank of India corresponding to new bank constituted banking companies, corresponding new bank constituted under the banking companies. Clear? So they all are the part of banking company. Okay. Certifying officer. Now you have to remember section 2G defines certifying officer for the chapter number 4. Now, what is chapter number 4? It is related to Industrial Employment Standing Order Act. Okay? So, who appoint the certifying officer? The appropriate government appoint the certifying officer. What is closure? Closure means the permanent closing down of the place of employment. Who is conciliation officer? Explained already. What is conciliation proceeding? Already explained to you. This is common in the law. Controlled industry. So usually we have studied CE, section 2EE, controlled industry under the Industrial Dispute Act. Here it is 2K, which defines working under the public interest. Employee, important definition. L, 2L defines employee. Who is an employee? Any person who is employed in an industrial establishment, including the apprentice, who is not covered into the Apprentice Act, for doing any kind of skilled, semi-skilled and unskilled manual operation, supervisory, managerial, administrative capacity. Also include a person who may be declared as an employee by the appropriate government, but does not include any person who is employed or a member of the armed forces. Next, employer. Now, this is again new. Okay? Something new has been added. Any person who employs directly or indirectly one or more employee in a work establishment, when it is the central government or state government owned establishment, head of department. When it is the local authority, it would be chief executive officer. When it is factory occupier and manager. When it is other establishments, so the authority by the name of manager or managing director will be the employer. Contractor would be employer, added new thing. And legal representative of deceased employer. This is something new added into the preventive regulative legislations. This is section 2M. Executive. Now this is related to trade union. We have studied this definition in trade union. Same definition. The body on which the management of affairs of trade union are interested. Section 2O, fixed term employment, very important. Will be asked. Can be asked. So which section under the Industrial Relation Code has defined the fixed term employment? This fixed term employment has been defined under the Schedule of Industrial Employment Standing Order, right? Newly added. Okay, it was added by the amendment. Earlier it was not there. It is also defined, it is also added under the standing order rules. No, model standing order. Okay, so what is the fixed? No. It is not in model standing order. It was only in the Industrial Employment Standing Order added by the amendment. Now, what is fixed term employment? Suppose an employee is there who enters into the contract which is written with an employer that you would be working with me for the term of at least 1 year. So they have entered into a contract, fixed period, that this is the fixed period that you are going to work. For this person who have entered into the contract, this person would be called as he is into the fixed term employment. So now he would be made to work. The working hours, wages, allowances, benefit will be actually not less than the permanent working doing the similar nature. So he should be treated as a permanent worker in the cases of wages, in cases of allowances. He would be also be eligible for all the statutory benefits as per the law, in proportion to the period of the service he is rendering. Okay. For example, when it comes to the gratuity requires 5 years. Minimum qualification required is 5 years. But here, as per the fixed term employment, if a person is under the contract of at least one year, he would be eligible for gratuity. Now, don't get confused that gratuity's eligibility have been changed. No. This eligibility of 1 year is only for the fixed term employment. Social security we will study the gratuities eligibility. Is this clear? So the person who is entering into the written complete contract would be treated as a permanent person, permanent employee. Industry, section P. Now again, this is a new definition. Systematic activity, any systematic activity carried on by cooperation between employer and worker whether worker is employed by such employed directly or through by the agency or through contractor, for the production, for the supply of distribution of goods and services, to view this satisfy human wants or wishes, not of spiritual nature. Now, this is something which is new added. Earlier, we used to study that in industrial establishment, where the manufacturing process is going on, processes like packaging, processes like making, building, so cutting, those were called as the establishment or the industry, and their dispute were supposed to be resolved. But now, all those establishments or all those areas where a systematic activity is being carried out, either for the production, either you are only for the distribution of goods and services, like Amazon, they are just distributing the goods and services, or to satisfy human wants like you're going to restaurant, ठीक है, आप वहां पे जाके अपने needs को satisfy करो. So this has been now covered. So not merely, but the spiritual or religious nature won't be covered. Whether or not any capital is invested for purpose carrying out such activity is carried out on the motive to gain profit or not. Whether such activity you are gaining the profit or not, whether you have invested your money or not in that, it doesn't matter. It would be called as an industry. But this does not include, is important, may be asked in exam. Institutions owned or managed by organization wholly or substantially engaged in any charitable or philanthropic service, not included. Any activity of appropriate government relatable to sovereign functions of the appropriate government, including all those activities on the department of the central government dealing with defense, research, automatic energy and space. So they are specifically excluded. Domestic service. What is domestic service? Maid. So if there is an contractor, if there is an middleman who is providing maid, you have domestic, we are providing the maids for the house, those services, or a person coming to someone's house and working as a domestic helper, no. Other activity which may be notified by the government, these are not included in the definition of industry. Industrial dispute, the same definition. Now, under Industrial Dispute Act, we studied industrial dispute under section 2K. Am I correct? Did we study the industrial dispute under section 2K? And we studied individual industrial dispute under section 2A. Now, those two definitions are combined here. So, any kind of dispute between employee and employer connected to the employment or non-employment terms of employment, plus any dispute which is related to the individual arising out of his discharge, dismissal, retrenchment or termination would be called as an industrial dispute, defined under section number 2Q. Clear? Is this clear? Right? Okay, let's move to the next quickly. Industrial establishment or undertaking, what would be called as an iske pehle we studied the definition of industry. Now we would be studying the definition for industrial establishment or undertaking. So which is carrying out the several activities for the establishment, all the activities related to industry. Now this activities, if any establishment or undertaking carry on any activity being an industry, is severable from the other units. So now this is like, this is an industry. There is a part of it or any unit of this is carrying out the activity which is servable. And not carrying or aiding, means it can be separated. So it is not carrying the activity which is related to the given. So this is the unit. It is carrying totally the activity which can be severable or separatable. So this would be considered as a separate industrial establishment or the activity. If a predominant activity of each predominant activity is carried on such establishment or any unit in an industry and other activities carried on such, okay, I'm not going to read. So now this any predominant ka matlab hota hai important. So for this establishment, let's say this unit is carrying on one activity is very predominantly running. So this can be considered as a separate industrial establishment or undertaking. That's it. Insurance company as defined under insurance layoff. Now, something new has been added here, important. Section 2KK defines the layoff. Triple K, double K, kya hai? What is the layoff section in Industrial Dispute Act? Here it is section number 2T. T T. So now T. So layoff. So just remember this L has been converted to T. So section T defines layoff. Same definition, but a person who has been retrenched, who present himself for the work of establishment at the time of appointment or purpose during normal working hours on any day and is not given an employment by an employer within 2 hours of presenting himself, then he shall be considered to be laid off for that particular day. So who would be laid off? If the what is the layoff? Any employer who is refusing, who is failing, or he is unable to hire any person because of all those shortage coal and shortage of material power or the raw material, that is layoff. But it does not include the person who is being retrenched. Now any person who appears himself, present himself in a given day for working hours, in a given working hours, within 2 hours of his presenting, like pehle ke 2 ghante, within 2 hours of his presenting, if employer is not assigning him any work, it is said that he is being laid off that for that particular day. Is this clear? Section number T clear? Sure. Next, lockout, temporary closing. Won't explain this again. Major port defined under Indian में metro railway added, new thing added. So metro railway would also be now covered here. Wow and where we'll study in coming slide. So metro railway defined in section W. So M को opposite लिखेंगे W. So this is how you have to remember where is the metro added. X define mine. So somewhere X means khatra. So mine is always danger, right? So X define mine. I'm giving you this mnemonics or this visualization so that you can recall them in the exam. National Industrial Tribunal, newly defined term. So earlier we have only industrial tribunal, we had labor code, we have your national tribunals. Now we have National Industrial Tribunal, something which is constituted under 46 section, which is tribunal. Section 2, why defined. So you have to remember this way. Why National Industrial Tribunal has been defined. So it is new. So why? So it is why. Z, negotiating. This is very important. Recognition provision has been added for the trade union. So for that, the body which get recognition is called as negotiating union or negotiating council. This has been defined in Z. So now you have to recall that last में आया, code में आया है, last में आया सबसे ज्यादा recognition, इसलिए alphabet का last one. ZA is the notification, which is the any notification given in the official gazette. ZB, office bearer. So OB, you remember अब Z के बाद चल रहा है तो ZB, office bearer, a person who is a member of the executive body. ZC, not that important. Railway, ZD, railways defined under Railway Act, not important. ZE. Now this registered offices for the trade union chapter, right? Any office of the trade union which is being registered, that is the registered office. Registered trade union, this is important, ZF. So earlier we have studied 2H, 2G. These are two important definition under Trade Union Act. 2H defines trade union and your 2G defines trade dispute. Am I correct or not? ये पहले dispute है, ये trade union है. कौन बताएगा? What is the correct answer? चलो 2H, what does 2H defines under trade union and what does 2G defines under the trade union? H is trade union. Yes, H is union and G is the dispute. G is registered office नहीं, registered office नहीं. H is trade dispute, G is trade union. ठीक है, चलो let's move to the next. Now ZZ registrar. So registrar, please concentrate here. Under Trade Union Act, the registrar was appointed by whom? Under Trade Union Act, the registrar was appointed by whom? Tell me the answer. Under the trade union, section number 3 says a registrar is a person being appointed by the appropriate government. Here, the power is given to the state government. Okay, not the appropriate government, it's state government. So this is the change. Section 2Z, retrenchment. Same definition which we have studied in section 00 of your Industrial Dispute Act. Here ZH. Okay, ZH. Same. All things are same. Okay. But one thing which is being added, termination of the service of worker as a result of completion of tenure of fixed term employment. Since fixed term is also defined, इसलिए. ठीक है. Settlement. Same definition. Which arises out of the course of conciliation proceeding, including the written agreement between employee and employer signed by both the parties, is called as settlement. Standing order. So remember, the standing order matters are given under first schedule of Industrial Relation Code defined in ZJ. Strike. Same definition, but the thing is added. What is that? And means a cessation of a work by a body of a people, yani number of the people coming together, by a concrete refusal, combination, common understanding with any number of the people doing so. But if there is an concreted casual leave given on a given day by 50% or more employees in an industry, it would be called as a strike. क्या एक किसी दिन में on any one day, if 50% or more people are going on casual leave together, it would be called as a strike. As defined under Industrial Dispute Act, it is 8 days. Sorry, it is 10 people when they are going on the leave together. वहां पे कैजुअल लीव की बात नहीं बोलते, वहां पे बोले तो लीव पे अगर चले गए 10 or more, it would be called as strike. It is said here 50 or more. Clear? ZL defines trade union, same thing. Definition is same. And also this we studied in the trade union, that chapter. Now chapter number 3 of this particular law talks about trade union. Okay? So chapter number 3. So if it comes to the trade union, the provision of chapter number 3 would be added, or chapter number 3 would be applying. So agreement, see, this trade union does not affect any the agreement between the partners. It does not affect any agreement between employer and those employed. Agreement of consideration of sale of goodwill. We have studied already this definition. So under the Trade Union Act, exactly same definition. Clear? Whether temporary or permanent in nature, combination. Dispute. Same definition. Any dispute relating to trade union arising between two or more trade unions or between member of trade union inter se. Now, something which is new added is, when there is an earlier what we studied, the dispute was any kind of dispute between employee and employer, or rather workman and employer, employer and employer, workman and workman. So the dispute was defined this way. Here it is saying any dispute relating to trade union between two or more trade unions or the member of trade unions. 2N tribunal, industrial tribunal. 2Y क्या था? National Industrial Tribunal. Tribunal, that is only industrial tribunal, ZN. Unfair labor practices are given under the second schedule of this law or this code, ZO. What it is? ZO. Unorganized sector have been brought under the provision of the code. It is the same meaning as defined under the Unorganized Social Security Act 2008. Okay? Now comes your definition for the wages. The complete whatever definitions you are going to study in this codes, either for codes of wages, either for industrial relation code, the two of them, codes of wages and industrial relation code, have got same definition for wages, and the definition is defined under the ZQ. So series of Z is starting, opposite of G, Q. So wages, what is wages? What does it include? All the remuneration which are in the way of salaries, allowances, or otherwise which can be expressed in the terms of the money, or are capable of being expressed in the terms of the money, in terms given in terms of the employment, either expressed or employed, where fulfilled be payable to the person employed in respect of the employment or a work done. Now, what does the wages include here? Basic pay, dearness allowance, retaining allowance if there it is there. So basic plus dearness allowance plus your retaining allowance if there it is. This is included. Other than this, there are few things which will be included when. What does it not include? Any bonus payable which does not form a part of remuneration. So payable under the bonus act, that bonus is not the part of wages. Value of house of accommodation, can you notice here, earlier under industrial dispute act, wages की definition में house of accommodation, supply of light, water, medical attendant, this was included. Now it has been removed from the inclusion part and included into, because this is anyways applicable to complete law, complete code. So value of house of accommodation not included, supply of light, water, medical attendance, other amenity, and so on. Pension or provident fund, any interest over it, conveyance allowance for the traveling, any different special expenses, any remuneration paid through the award or settlement, house rent allowance not included, any overtime not included, any commission payable to employee not included, any gratuity payable on termination not included, any retrenchment or the retirement benefit, extra gratia not included. This is not included. Included basic plus DA plus retaining allowance. But now there is a condition. What is the condition? There is something new which is being defined. Now this has been already defined under payment. ये deemed remuneration की definition is defined under Payment of Wages Act, and any other law did not define the deemed remuneration. Now what is this deemed remuneration? Now we, from clause A to clause F, sorry, I, up till I, from clause A up till clause I, when a payment is made to an employee from clause A to clause I, if it exceeds 1/2 or such percent as be modified by the central government of all remuneration clauses calculated under this clause. What does this mean? Let's say A से लेकर कहां तक, K तक, from clause A to K, from clause A to K. If suppose the complete sum of this A to K is 10,000 rupees, how many? 10. So any bonus is 500, value accommodation is 250, and so on, and the total comes around 10,000 rupees. Deemed remuneration says that if A to K, now only from A to K, first total is 10,000, from A to K, sorry, A to I, from A to I, if only this I till I, if the sum is more than 50% of this 10,000, means let's say it is 5,500 or 6,000. So whatever the extra amount is there, so if it is 5,500, this 500 exceeding amount, and if it is 6,000, so इसका 50% कितना होता है? 5,000. So exceeding amount is 1,000. This 1,000 would be considered as a deemed remuneration. Means while adding this basic dearness and retaining allowance, one more 1,000 would be added, or whatever the extra amount comes. Is this clear? समझ में आ गया? This is one condition, another I will explain you. Is this clear? नहीं पूजा, नहीं समझ में आया? डिडंट यू अंडरस्टैंड पूजा? नहीं, चलो, I will explain the another condition and then I will explain you completely. Now, second, if the amount which exceed one half or the person so notified shall be deemed remuneration. So that is what I explained you, and it would be added into the wages part. Any remuneration. This is one condition. Another condition. Any remuneration which is payable to the employee by an employer in a kind. In a kind like Amazon pay card, Sudesco card. Now, if this in-kind payment amount, is not exceeding 50% of total wages, if it is not exceeding, let's say it's total wages of basic plus DA plus retaining allowance is around 10,000 rupees. What is 15% of it? 1,500. So any of this in kind, if it is not exceeding 1,500, less than 15%, let's say 1,200 ka card diya, Amazon card of 1,200, then this in kind amount would be considered as a deemed remuneration of the wages, provided for all purpose of equal wages of all gender for purpose of payment of wages, emolument specified D, F, G, H shall be taken for the computation of the wages. Equal wages to all gender. This line is very important, that when you are paying equal remuneration for equal or same kind of the work, what all things you would be calculating? D, F, G, H. D, F, G, H have to be equal. So if somewhere you are giving the overtime something to male part, then counterpart female should get that overtime. And if it is the remuneration in case of award, it has to be equal, right? So this is what the last line says. Is this clear? Now, is this clear? Chalo, we'll explain you by the example if you have not understood. Okay, give me a second. Okay, is this slide visible? Okay, I hope that is visible now. Blank. See what the definition of the remuneration is. Wages include basic plus DA plus retaining allowance. Okay? And does not include, we have clause A to K. Right? We have the clauses A to K. Now there is a term called deemed remuneration. Deemed remuneration means it will be considered as a part of the wages. So if from clause A to K, let's say bonus is 500, overtime is some, not overtime, house of accommodation value is somewhere 1,500. Complete A to K. ठीक है, कहाँ तक? हाँ, K तक. If A to K, the total comes around 10,000. How much? Total is 10,000. This is 10,000. Now, deemed remuneration says that if the total of A to G, I, A to I, हाँ I, ठीक है, A to I, यहां तक का A to K का सम क्या है 10,000, क्लॉजेस सबका क्लॉज का सम 10,000 है. Total, if the total of A to I is exceeding 50% of this, what is 50% of this? 5,000. So let's say this is 6,000. Exceeding 5,000, it is more than 50%. So the extra amount, how much it is exceeding? By 1,000 rupees. This 1,000 extra exceeding amount would be considered here. So if basic is 7,000, DA is 3,000, retaining is 1,000. So the wages for the person is 11,000 here. But in case if this 1,000 is exceeding, this 1,000 would be added here. So the wages would be 12,000. Clear? Also, if some in-kind amount is being paid, in-kind में पैसे दे रहे हैं, cash में नहीं, Sudesco coupon, Amazon card or anything else. If the value of this in-kind is not exceeding 15% of the total wages which is being paid, total wages whatever is being paid to him, if it is not exceeding 15% of that total wage, then not exceeding बोल रहा है, तो let's say ये 10,000 तो इसको total हो गया, let's say 15,000 or 20,000 is his salary. So if this Sudesco is not exceeding 15% of this 20,000, that lower amount will be considered as a part of the deemed remuneration. Is this clear? Is it stucking? Is this clear, everyone? Yes, Pooja. और यहाँ पे छोटा वाला अमाउंट 15% से कम वाला अमाउंट होगा. चलो, let's move to the next definition. Worker, ZR worker. तो as the name pronounce R, worker, ZR. Any person. Have you noticed? There is a different definition for employee and there is a different definition for the worker. Notice किया? थोड़ी देर पहले we studied the definition of the employee and now here we are studying the definition of the worker. Means a person except the apprentice. In employee it was included, here it's not included. Any person except the apprentice, so apprentice is not included. Employee in an industry to do any kind of skilled unskilled labor. Now new thing which is being added here is working generalist as defined under Working Generalist and Other Newspaper Employees Condition and Service Miscellaneous Act of 1955. Sales promotion employees as defined under section 2 of the Sales Promotion Condition and Service Act of 1976. So your generalist, sales promotion, these people are now called as worker for specifically for industrial dispute, and it include person to be deemed as a person who is being dismissed, discharged, retrenched or otherwise terminated. They all would be called as a worker, but does not include Air Force person who is subjected or getting the or who are covered under Army Act of 1950 or Navy Act of 1957, one who is employed in police service or an officer of the employee of the prison, one who is employed mainly in the managerial or administrative capacity, who is supervisory capacity, wages drawing 18,000 rupees per month. Industrial Dispute Act में बताना क्या है? What is the Industrial Dispute Act? As per Industrial Dispute Act, supervisory का wage ceiling, here it is raised to 18,000. Who can tell me? Correct, 10,000. Here it is 18,000. Now, specifically for trade union chapter means all the person employed, the worker would be. ठीक है, इन सब के अलावा जो हम ट्रेड यूनियन की बात करेंगे वहां वर्कर की डेफिनेशन क्या होगी? All persons employed in trade or industry and include the worker defined under section 2 of the Unorganized Worker Social Security Act of 2008. Done. Is this clear to everyone? Chapter number 2. Chapter number 2 talks about the bipartite bodies or the bipartite forums. Chapter number 1, what was chapter number 1? Short title and definition. Chapter number 2, bipartite forum. Chapter number 3, your trade unions. Chapter number 4, standing order. Right? We will move slowly. So what is chapter number 2? Bipartite forum. Now, how many bipartite forums are defined here? Work committee. This is section number 3. Same section is in your Industrial Dispute Act. So wherever there are 100 or more employee working or employed in an industry, the appropriate government may order the employer to constitute the work committee consisting of equal number of representative of employee and employer. Among this workers, the workers representative would be selected, or you can say selected by the consultation of trade union if there is a registered trade union. The work of this committee is to promote measures for securing and preserving amenity and good relation between employer and worker, and that to end comment upon the matters of common interest or concern, endeavor to compose the material indifference. So simple, to settle down the dispute. Clear? Anything has not been much changed here. Section 3, section is also same, requirement is also same. Section 4, section number 9C under the Industrial Dispute Act, Grievance Redressal Committee. It is here section 4. Grievance Redressal Committee, wherever there are 20 or more people employed in an industry, there should be a Grievance Redressal Committee, equal representative of members of employee and employer. Chairperson are alternatively selected from employee and employer representatives on yearly basis. The maximum number should not exceed 10. In Industrial Dispute Act, it is 6. And there should be an adequate representation of the women workers in the Grievance Redressal Committee, and representation of shall not be less than the proportion of women workers of total workers in the establishment. What does this mean? So if there are 10 members, 5 employee, 5 employers, since it is a bipartite body, so 5 employee, 5 employer. Now let's say total workmen in an industries are somewhere 100, and women's here are, let's say 50, or let's say 50. So what is the proportion of the women to the total worker here? 50%. So in this 5, so this is not something which can be divided in equal part, but in suppose it is 6, or let's say, let's take it as 8 members are there, 4 employee representative, 4 employer representative. Women representative has to be into the same proportion as the women's employed in the industry. So it is 50% of total women as compared to total workers. Here also, if there are 4 representative from the employer, 50% of it has to be women. Okay? 50%, just a figure I am giving you. If out of 100, 30 are women, then 30% here also 30% has to be women. Is this clear? Grievance Redressal Committee has, so any aggrieved person who is having a grievance, he will raise an application, make an application within 1 year. Within 1 year. The Redressal Committee will be completing the complete proceeding within 30 days. Now, any application, the decision of Grievance Redressal Committee on application of field shall be made on the basis of majority view of the committee. जो भी decision आएगा, the decision would be based on what majority people are agreeing. Provided more than half of the member representing the worker have agreed on such decision, otherwise it is deemed to not to be arrived at by the committee. मतलब क्या? Employee, employer representative. Here we have 4 employee representative, 4 employer representative. The maximum, or say out of this 8, 7 people are saying yes, we agree on this decision. But from this 7 also, more than this, half of the employee representative should agree on that decision first. Then it would be a decision. The worker who is aggrieved by the decisions of the Grievance Redressal Committee from 60 days, earlier was, पहले कितना था? कौन मुझे बताएगा? Appeal can be made to the employer. Who can tell me? Earlier, if a person who is not sat 30 days, right? It is 30 days. And appeal was to made to whom? Appeal was to be made to the employer. Here, the appeal is to be made or file an application for. ठीक है? द कंसिलिएशन ऑफिसर. ठीक है, कहां पे है, एम्प्लॉयर नहीं है यहाँ पे, ये कंसिलिएशन ऑफिसर के पास जाएगा. ठीक है, इट्स नॉट एम्प्लॉयर, इट्स द कंसिलिएशन ऑफिसर. नाउ in case he applied an application to conciliation officer, it has been the 45 days, no decision has been made, then after the expiry of this 45 days, the you can say the grievance, the worker can make a application directly to the tribunals. Under Industrial Dispute Act, it is labor court, but here it is tribunal, because labor court is not defined under your new codes. Okay, now tribunal will be exercising or giving the jurisdiction, adjudicating the matter. Such application to the tribunals have to be made before the expiry of date of discharge, dismiss, retrench, or otherwise terminated. So specifically for the individual person dismiss, discharge, it has to be made before the expiry of 2 years. Clear? Is this clear? समझ में आ गया? What all things are being new added? Everyone understood? Correct. Clear? Sure. These are the two bodies, bipartite forum. Now chapter number 3. Everyone has the patience? Should we take 1 minute pause? We'll do the chapter 3 also. We'll finish the chapter 3 also. Patience hai? 1 minute pause and we'll do this. No bus, no car, no auto, no rickshaw. No. No bus, no rickshaw, no auto, no car. Have 1 minute pause and we'll finish up this. ALC stuff. Okay, we'll finish this. Just have 1 minute pause and we'll finish this. खुद ही डिफरेंशिएट करना पड़ेगा. Few people. Shall we start? Sure. Thank you, Pooja Pyle. Thank you. I want to finish this up today itself without any. Now my laptop has started stucking. I don't know why. It is stucking. It's heating up. Anyways, let's start. I hope that's visible, the slide of the. Now, chapter number 3 talks about trade union. Nothing is different, only the section 14 has been added, something extra, recognition. Now, trade unions. Section number 5 defines registrar of the trade union. Under Trade Union Act, it was section number 3 which talked about registrar. Here it is section number 5. So under Trade Union Act, appropriate government was responsible to appoint the registrar. Here the state government, by giving a notification in the notification in the official gazette, can appoint the registrar. Registrar can have an additional registrar, joint registrar, deputy registrar, and they all would be doing the duties which are being assigned to them by the state government by notification in the official gazette. Criteria. Section number 6 here talks about criteria. under Trade Union Act, section number 9A was talking about minimum section number 9 was talking about the criteria for the registration. So 7 or more people of the trade union with their names accompanying all the provisions required which are given into the code will apply for the registration of the trade union. Now, when a trade union is being applying for the registration, during the application, 10% of the workers of or the 100, whichever is less, should be engaged in the industrial establishment when they are making an application, that is date of application. The application will be not merely considered invalid if half not exceeding half, so it should not exceed half. If less than half person who made an application ceased or they left the membership of trade union by giving in a notice to the registrar, but if it exceeds more than half, then application would be valid, but if it is less than half, it won't be invalid. The registrar, the trade union which is being registered, all time have to fulfill the minimum criteria of not less than 10% of the workers or 100 workmen, whichever less, subject to 7 engaged or employed in an industrial establishment. This is the combination of section 7, section number 9, section number 9A, section number 10. Combination of everything has been made into the section number 6, minimum criteria. I hope that is clear. Section number 6, under the Industrial Dispute Act, was talking about the rules which was added by in which the amendment of 2001 added few subscription amount and all. So here also, when in trade union which is looking forward for the registration under this code, the code when the trade union when making and registration application should follow this rule. What? It should prescribe the particulars like name of trade union, whole of object of trade union, purpose of general funds, list of the members of member of trade union and the educate facilities to be provided during the inspection, admission of the ordinary members irrespective of craft or criteria. Ordinary members mean those who are not the insiders, those who are not the part of the trade union. So what is the how you are allowing the ordinary members to actually enter into the trade union, or who are the part of industrial establishment but not the member of the trade union, they are called as ordinary members. Also the admission of those people, those who are honorary or the temporary members, who are not such workers are not permitted to under section 21 to be the office bearers of executive. So ordinary members जो लोग trade union के member नहीं होते but they are the part of industrial establishment, and your honorary or temporary member जो office bearers नहीं होते but they are the part or they are allowed to enter into the trade unions. Now subscription amount, the payment of subscription amount would be paid by the members as prescribed. So here still now the rules have not been disclosed that what is the amount. So the subscription members will be making a payment. Conditions under which a member shall be entitled to any benefit assured rules under fine or forfeit may be imposed on. And now this rule will also contain that what are the condition in which you are giving a benefit to the employee, in which condition you are applying fine to the person. General annual meeting of members of trade union business, when it is going to be take, including election of the office bearer when it is to be happening, how the members of executive and other office bearers are to be elected. Here also it is 3 year, once in a 3 year. There was also once in a 3 year. Where and how the safe custody of the funds have to be kept, annual audit how it would be done, how the rules may be amended, varied or re-signed, and the manner in which the trade union are dissolved. Everything is same as the Trade Union Act. Now, application for registration, alteration and procedure thereof. While making an application for registration of the trade union under this code, the application shall be made to a registrar. How? Electronically or other way, accompanied by a declaration made by an affidavit in a such form as manner may be prescribed. So there would be a declaration which is by the affidavit So declaration of what? That we want to make a registration. Copy of rules have to be added. Copy of resolution of adopted by the members of trade union. Resolution, हमने क्या, हमारा objective क्या, हमारे क्या resolution है, what as a trade union members we are going to do. In case of a trade union which is federation or a central organization of the trade union, a copy of resolution adopted by member of each member of trade union meeting separately agreeing on constitute of federation. So now the point here which is added is that if you want to alter your name and if you are a central or federation, then you have to give all the details, right? Where a trade union has been in existence for more than 1 year before making an application, the application should have a general statements of liabilities and assets, same. The registrar can call for the more information if he is looking forward to satisfy that the trade union which is making an application is fulfilling the criteria or not. So the registrar may refuse the registration of the trade union if he is not satisfied. If the name of the trade union which is being making an application for registration is identical to already existing trade union name, the registrar will ask him to change it. Okay, he may ask him to either refuse the registration or alter the name of the trade union. When the registrar is satisfied, that trade union is completing all the details, he will give the registration. However, the registrar can withdraw the registration of the trade union. When? What are the conditions? First, if the application is made by the trade union, if the trade union is contravening any provision of the code or the rules, if registrar is satisfied that the trade union has fallen below the 10% or 100%, so not fulfilling the minimum criteria, provided before it makes a cancellation, he will give 60 days notice. Trade Union Act में कितना दिन का नोटिस देते हैं registrar? Tell me, how many days notice in the trade union? It is 60 days here. वहां पे क्या है? 2 months. Correct, right? Give me a second. Okay, so here it is 60 days. Now another thing, certificate of registration of trade union can be cancelled by the registrar where the tribunal has made an order to cancel of the registration of such trade union. So if a tribunal make an order cancel the registration of the trade union, it can be done by the registrar. Appeal if the registrar is not registering, cancelled the trade union's registration, appeal can be made to a tribunal within the such period as may be prescribed. So it is again 60 days. ठीक है? No. हाँ, 60 days as per the rule. लेकिन अभी नए rule में defined नहीं है. Earlier rule is 60 days. So tribunal, after giving a parties and concerned opportunity to be heard, may dismiss or pass an order directing a registrar to register the trade union. So appeal will be made to a tribunal. Tribunal will listen to it and he may give an order to the registrar, please register the trade union and issue the certificate. He can keep aside the cancellation or cancellation of the certificate of registration whenever he feels so. If tribunal feels so, it will do it. 11. Communication of trade union and changes in registration particular. All communications and notices which is to be sent to the registered trade union will be made at its registered head office, and trade union, though that address, that head office address which is mentioned into the registration of trade union by the registrar. ठीक है, जो रजिस्ट्रार रजिस्टर्ड ट्रेड यूनियन का रजिस्टर बनाता है, उस पर्टिकुलर रजिस्टर में व्हाटएवर एड्रेस इज मेंशन that address would be used for communication. If the percentage of the members of the trade union falls below the 10% or 100, whichever is less, it is the responsibility of the trade union to inform the registrar. If anything is being changing into the particulars when the application was made for the registrar or any constitution of the rules, the trade union will inform the registrar that these are the changes, and everything has to be done from its head office. Incorporation of registered trade union. So what does this mean? Section number 13 under the Trade Union Act defined this, that every trade union which is registered is a corporate body, will have perpetual succession, common seal, acquire movable and immovable property both, can sue, can be sued. Under section 14, under Trade Union Act, the list of the act which were not applicable, on which the Trade Union Act is not applicable, was given. There were 3. Here are 5. Societies, this is earlier already there. Cooperative societies was also there. Companies Act was there. Now something which is added, Multi-State Cooperative Societies Act of 2002 and any other corresponding law relating to cooperative societies for time being force in a state shall not apply to any registered trade union and registration of trade union under any forehand. So it won't be applicable. So remember these sections, one section they have moved backward. Okay, corporate body section 12, and where it is not applicable, section 13. Section number 14, very important, which talks about recognition of negotiating union or negotiation. Now this is recognition. The trade union would be recognized to enter into collective bargaining process. Now there can be a negotiative union, means a single trade union given as an status of negotiating union to enter into the collective bargaining, or number of the trade union to enter into collective bargaining collectively. So when there is only one registered trade union, and employer of such establishment, basis of the criteria, after fulfilling the criteria, will recognize that particular trade union as a negotiating union. But if there are more than one trade union in an industry, and after the fulfillment of the criteria as prescribed by the code, what is the criteria? That trade union having 51% or more workers on muster roll of that industrial establishment supporting. Okay, so now this is like, acha, so sorry, hold on. What does this says? Just forget, I was into the different thing. So first thing about negotiating union and negotiating council, if only one trade union is existing, if it fulfills the criteria as per the code, the employer will register it as a negotiating union. Now if there are more than one trade union, which trade union would be registered as negotiating council? Any trade union which is having 50%, more than 50% of membership of the industry, that trade union would be declared as negotiating union. Now, if any of the trade union, there are number of trade union, and no trade union is having more than 50%, in that case, every such trade union which is having at least more than 20% of total workers of the industrial establishment, those trade union would be collectively registered or recognized as a negotiating council. Either negotiating union or negotiating council, they will have that recognition status for the valid period of 3 years. Okay? And recognition or constitution of further shall not be exceeding 5 years in total, as may be defined. So now this 3 years can be extended to 5 years. Section number 14, is this clear? Please do let me know. समझ में आया? Whatever I said. हाँ, वहाँ 67%, कहाँ 60%? पूजा, कहाँ 67%? वहाँ टेन्योर कहाँ था? वो कहाँ था? ये किसका है? हमारे लॉ में तो रिकॉग्निशन है ही नहीं ना, पूजा recognition is given in the code of discipline. कोड ऑफ डिसिप्लिन में रिकॉग्निशन था, ठीक है. डोंट गेट कंफ्यूज, ट्रेड यूनियन एक्ट डज नॉट गिव द रिकॉग्निशन, इट इज द क्राइटेरिया इज गिवन अंडर द कोड ऑफ डिसिप्लिन, ठीक है. चलो नेक्स्ट, ऑब्जेक्ट और द फंड, जनरल फंड, कंपोजिशन ऑफ, सी दोनों को कंबाइन कर दिया. देयर वाज सेक्शन 15 जनरल फंड, सेक्शन 16 पॉलिटिकल फंड, इट कंबाइंड हियर इन सेक्शन 15 दोनों. So our general fund will be only not of the registered trade union will not be spent as other than the objects which may be prescribed, and the trade union can be allowed to constitute a separate fund for the political purpose, ठीक है. Now this political purpose is not compulsion, no one can be compelled to contribute for forming the separate fund for the political purpose. The subscription amount which are payable by the members of trade union will be decided or prescribed by the code. So section number 16 and section number 17, sorry, section number 17, section number 18, this was immunity against the civil court and this was immunity against criminal conspiracy. right, उल्टा था, क्रिमिनल कॉन्स्पिरेंसी पहले था और सिविल सूट बाद में था, यहाँ पे इसको उल्टा कर दिया, ठीक है. 17 में ही क्रिमिनल कॉन्स्पिरेंसी है लेकिन 16 में सिविल सूट ऐड कर दिया. सो नो लीगल प्रोसीडिंग शैल बी मेंटेनेबल और कैरी अगेंस्ट द रजिस्टर्ड ट्रेड यूनियन और द मेंबर्स, ऑफिस बेयरर्स और द मेंबर्स ऑफ द ट्रेड यूनियन in any act done in contemplation of furtherance for the industrial dispute, not liable for suit or legal proceeding in civil court in respect of tutorious act done. Same thing, every condition is same. No criminal, no action against the criminal conspiracy. So no office bearers, no registered trade union shall be liable for the punishment against the criminal conspiracy. Enforcement of agreements, same. Enforceability of agreement says that if any law for time being or agreement is for time being is applicable on the industry, this agreement is between employee and employer, the trade union act will not affect that agreement, it will be applicable as it is, ठीक है. Inspect the books. So books of the registered trade union can be inspected by an office bearers, ठीक है, and the trade unions as per the rules provided. Right of minors, a person who has attended the 14 years, tell me trade union act में क्या है, कौन सी एज दे रखी है, tell me trade union act में minor, right of minor, how much age should be completed to become a member of trade union. Clear? चले, yes, वहां 15 था, यहाँ पे 14 years है. So one who has attended the age of 15 years would be allowed and not involved in hazardous process, but yes, condition is not employed in any non-hazardous process, can be a member of registered trade union. He can enjoy all the rights of the trade union, but he cannot become a member of executive, ठीक है. Member and execute all the instrument and given acquaintance necessary, ठीक है. Disqualification of office bearer, one who has not attended the 18 years of age, one who has imprisoned, sentenced to imprisonment, same thing है, ठीक है. One who has not 18 years of age will be disqualified. One who is sentenced to the imprisonment, but after the 5 years of imprisonment has lapsed, he can become, ठीक है. Then a tribunal can direct, ठीक है, can direct that he shall be disqualified to become or chosen an office bearer or trade union on the specified reason for the specified period. So tribunal has a power that it would be 5 years, 2 years, 3 years, or what. No member of council of minister holding the office of prophet would be allowed to become a member of the office bearer. Okay, same thing. So in the union or the state shall be an executive member, चाहे वो union का हो चाहे वो state का हो, दोनों के लिए he is not allowed to become. Clear? Now, adjudication of dispute of trade union. This is added new related to adjudication. When there is a dispute between one trade union and another, or one or the members of trade union, okay, if there is a dispute between one trade union and another, one or more workers who are member of trade union regarding registration, administration, management, or election or office bearer of trade union, one or more workers who refuse the admission of member of the trade union, where a dispute is between the federation of trade union office bearer and authorized, all such dispute would be adjudicated by the tribunal having the jurisdiction in the area where the trade union's registered office is located. No civil court other than these tribunals shall have a power to entertain the suit or the proceeding related to this dispute. So where it has to be prescribed, or it can be adjudicated by the tribunals for the area where the you can say registered office has been, there is a registered office for the trade union in that area. Clear? Sure. 23, proportion of office bearers. So there are two conditions for unorganized sector and other cases. For unorganized sector, not less than half of the total member of office bearers, okay, should be connected to the industry. At least half has to be connected or engaged in the industry. In other cases, not more than 1/3 of the total member, or 5, whichever is less, has to be connected. Same hai, same, it is same as that of trade union. Change in the name of trade union, amalgamation, notice of change. So when the registered trade union want to change the name, not less than 2/3 of member of the trade union members consent is required. The 2 or more trade unions can be amalgamated. Now when there is an application made for amalgamation and the change in the name, the application has to be signed by the secretary and 7 other members of the trade union, both the cases by secretary and the 7 other members. And this application has to be sent to the registrar where the head office of the new amalgamated trade union is located. The place where the trade union will be amalgamated, that area, the registrar would be sent an application. The change in the name of the trade union, new name, will not affect the rights and obligations of the old trade union. It will effectively only run by the new trade name. So it will just start running by new name. And the amalgamation of trade union will not actually amalgamate or mix up the liabilities. Same hai, right? So that was your chapter number 3. Is this clear? Is this clear? Khatam ho gaya chapter 3. 24 tak chapter number 3, trade union. Oh, now patience. Chapter number 4, standing order. Do you have the patience? Pooja, you are only in the class, other left the class. Okay. See, you can leave the session I would just take the session. You can see the recorded. ठीक है, मैं पढ़ा दूंगी इसे, आप रिकॉर्डेड देख लेना, ठीक है. It's okay, even if anyone is not there, I will take this. At least we'll finish chapter number 4, standing order. File is not there. ठीक है. Yes. Thirty seconds. Okay, thank you for being there. Let's start. Standing order. Fine. So chapter number 4 talks about standing order. So this is related to Industrial Employment Standing Order Act, where this chapter would be applicable. So as per Industrial Employment Standing Order Act, the act is applicable where there are 100 or more workers being employed in an establishment. here this chapter of standing order under the code will be applicable to every industrial establishment where 300 or more than 300 workers are employed in preceding 12 months. But notwithstanding contained in subsection 1, other than this 300, the provisions won't be applicable to this. Where it won't be applicable? In those industrial establishments where already fundamental and supplementary rules, civil service classification control rules, civil service temporary service rule, revised leave rules, civil service regulation, civilians defense, these rules are applicable. There the chapter won't be applicable. This was given under section number 32, I think so, under Industrial Dispute Act. Another important. Now, model standing order. This we study separately. This model standing order is being framed by central government. Now, under IR code, this provisions has been added under section 29 that the model standing orders can be framed by the central government for the temporary application. Temporary application means till the point of the time the provisions of the chapter number 4 are not applicable to any industrial establishment, for the temporary purpose the model standing orders can be applied. So these are actually formulated, or the power is given by the central power is given to the central government. Okay. Now whenever any industrial establishment is actually applying the model standing order, it is said they are applied as if they are standing order which are certified. That is section 29. Section 30, draft. Any industrial establishment which is having or containing 300 or more employees have to draft a standing order. This draft, whenever the act becomes applicable, whenever the chapter becomes applicable on any industrial establishment, within the time period of the 6 months, a draft has to be prepared. Okay, the draft has to be based on the model standing order as referred in section 29, and all the matters of the standing order should cover the matters given in the first schedule. So as per the model standing order and cover the all the matters given in first schedule. While drafting this standing order, the employer shall consult the trade union or a recognized trade union's negotiating union or a member of negotiating council. This was not in the standing order, but now consultation has been added. Once the draft has been prepared, it would be sent electronically or otherwise to the certifying officer. Where an employer who have already adapts the model standing order of the central government of the standard already following the models, it is believed that it is deemed to be certified. They don't have to take a separate certification for them. Clear? Provided the certifying officer can ask that establishment which is following model standing order to get the draft certified in the given period of the time. Preparation of the draft standing order by employer and procedure for certification. So the draft will be prepared by the employer and consultation would be done. After consulting the trade union, it would be forward electronically within the 6 months. Once it has reached the certifying officer, the certifying officer will issue a notice to the registered or recognized trade union, negotiating union or negotiating council. Now the notice has to be given that we have received draft. In case there is no trade union which is operating in an industrial establishment, then such representative of the workers may be undertaken or may be chosen for the sending the draft. They will receive the notice and they will comment if they have any objection. They have the opportunity to comment, okay, modify. So this trade union's representative will decide. So they if they want to change anything, they can actually comment on it or make an application to the certifying officer. Now this certifying officer will later on decide whether the things have to be changed or not. Provided certifying officer will complete the procedure of certification of this standing order within the period of 60 days from the date of receipt. कितने दिन में? 60 days. So draft modification in the standing order so received within the period of 60 days from the date of receipt, such modification failing to with standing order as case may be modification have been certified on the expiry of said period. 60 days received by the certifying officer. If certifying officer is not communicating, automatically it is believed that it has been certified. Now, the standing order shall be certifiable for the code, all the provisions of the code, or the certification would be given if all the provisions for all the matters given in the first schedule are fulfilled and it is confirming the provisions of the code. This is necessity. This is necessary requirement that the certifying officer will certify. In case if certifying officer is actually registering or certifying the standing order, it is his responsibility and appellant authority's responsibility to make sure that the provisions are followed. The provisions of the model standing order are followed. Clear? Now, the certifying officer shall certify the standing order, draft standing order modification, and shall within 7 days send a copy of certified standing order authenticated by him to the employer, negotiating agent and negotiating counsel. How many days? 7 days. Clear? Now, if any modifications have to be made, any new modifications have to be made under this draft or certified standing order, such statement and such particulars has to be prescribed by the employer with consultation with the trade union, and then it would be forwarded to the certifying officer. Okay? So what exactly you have to remember here is in section 30. Complete procedure of standing order certification is same. The only thing is here the consultation of employee has been added, plus the number of days for completing the procedure is added. 60 days. You have to complete the procedure into the 60 days. Who? Certifying officer. Once the procedure is completed, certification is given, they will send a final certified copy within the 7 days of completing the completing the certification or modifications. Clear? Now, appellant authority or certifying officer will have the power of the civil court while they are giving the certification. Appeal. If any trade union, negotiating union or negotiating council or even an employer is not satisfied or it is having any objection related to the certified standing order, they can appeal within 60 days. Earlier it was 30 days. They can appeal 60 days to the appellant authority. Okay? To the appellant authority who is appointed by the appropriate government, and the appellant authority will deal with the matter. Date of operation of the standing order, from when the standing order would be applied. So there are two cases: appeal is made, appeal is not made. If the standing order which are certified is not appealed by trade union or employer, it will come into the operation on the expiry of 30 days from the date on which authenticated copy was sent. If it is appealed, okay, so if it is not appealed, 30 days, and if it is appealed after the expiry of 7 days from the date when appellant authority sends the final order. Now, every certified standing order under this code has to be maintained by the employer in a language which is being concerned to the worker, means understandable to the worker. Registrar of the standing order. So the register of the standing order the standing order which has been finally certified under this code will be filed by a certifying officer or uploaded electronically in a prescribed manner. Means it is the responsibility of certifying officer. Duration and modifications, if any modification or durations have to be made, it cannot be made until and unless the certificate standing orders have been you can say expired. But any if modification has to be made, there should be a gap of 6 months. Means last modification and new modification until the expiry of the 6 month from the last modification made. Clear? Whenever any modification is to be made, the same format, they have to send the draft in consultation with the trade union. No oral evidence is admissible. If any objection, anything is contradicting the standing order, oral evidence are not accepted. Interpretation. Now, if any of the dispute arises related to the standing order in any industry, such matter of dispute would be referred to tribunal. Earlier in the law, it is labor court. Here it is tribunal. Tribunal within which the local limits of the territory whose wherever the industry is located. So it's in suppose there is an industry, in whatever jurisdiction the industry is coming, in that jurisdiction the tribunal, the matters would be held upon. Time limit for completing disciplinary proceeding until the payment and the liability of payment of subsistence. This is under section number 10A of Industrial Dispute Act, subsistence allowance. This says that any person who is being suspended pending investigation against the complaint of misconduct, the investigation or inquiry for such suspension have to be completed within the period of 90 days. How much? 90 days. And a person who is being suspended is supposed to get a subsistence allowance. It is at the rate of 50% for first 90 days and 75% till the point the proceeding is going on if delay is there. But this delay should not be because of the conduct of the worker. So delay should not be because of the worker. Then only 75%. 39. Power to exempt. Appropriate government conditionally or unconditionally can exempt any industrial establishment from this particular provisions or the chapter. New thing that has been added here is that proceedings, disciplinary proceeding being carried out against the suspended employee has to be completed in 90 days. That is your chapter number 4. Now chapter number 5, we will be doing it tomorrow. Clear? Clear? So thank you so much for your patience. We'll do the next part tomorrow, and we'll finish up the industrial code tomorrow. Okay? Sure. हाँ, subsistence नहीं, जो disciplinary process है, that disciplinary process have to be completed in 90 days. ये add हुआ है, बाकी तो same है. ठीक है? So thank you so much. I hope you enjoy तो क्या ही किया होगा, but I hope you understood the class, understood the things, and we'll meet tomorrow. Thank you so much.